Okay, you go to the pharmacy to pick up your heart medication. Your doctor wrote Vascepa on the prescription. The pharmacist hands you a generic bottle and says, same drug, much cheaper. You take it. Happy ending, right?
Yeah, I mean, that's how it works. Save money, same medicine.
Right. Now, here's the twist. What if the company that made the generic described its drug in ways that, according to the brand name manufacturer, secretly encouraged doctors to prescribe it for a patented use? And what if the secret encouragement they're talking about came from investor press releases that mention sales figures?
Wait, press releases to investors count as inducing doctors?
That's exactly the question the Supreme Court now has to answer. And the stakes go way beyond one drug company.
Welcome back to the High Court Report. Today, we breaking down Hikma Pharmaceuticals versus Amarin Pharma, a case about generic drugs, skinny labels, and whether calling your product the generic version of a brand name drug can get you sued for patent infringement. The High Court hears oral arguments on April 29th, the last day of oral arguments for this term. We're finally here. Can you believe it? The court actually hears two cases that day. I'll run my final case preview after the first batch of oral arguments. Wow, I can't believe we made it this far. Quick thanks to you, the audience, for making the podcast what it is today. I started the podcast almost exactly 1 year ago, not knowing where exactly it would lead. It's evolved and expanded. Thanks to you all for sticking with me, subscribing, rating, sharing, and commenting. And a special thanks to my guests, Adam Feldman, Adil Bashir, and Mark Blueball. The fun won't stop though, as Adam Feldman said in our interview. Expect a loaded May and June. That's when most opinions will drop. We'll cover them all.
And with that, here's a quick reminder. Please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn too. Just search the High Court Report. Questions about this case? Reach out to us via LinkedIn at the High Court Report.
And look, we know following a podcast feels less exciting than, say, filing a patent. But statistically, it takes fewer steps and costs significantly less than $300 million.
Here's what you need to know.
In this case, the Supreme Court must tackle two questions. First, when a generic drug label fully carves out a patented use, do allegations that the generic maker calls its product a generic version and cites public sales data about the brand drug amount to enough to plead patent infringement? And the second, can a complaint survive a motion to dismiss for inducing patent infringement if it doesn't allege any statement by the defendant that even mentions the patented use?
Let me translate. Generic companies have a legal tool called a skinny label, a label that deliberately leaves out the drug uses still protected by patents. The idea, you can sell the drug for the unpatented uses and stay out of trouble.
Right. But here, the brand company, Amarin, says Hikma did something more. It says Hikma's press releases and website essentially sent a signal to doctors. Hey, our generic does everything Vascepa does. And Amarin says that signal crossed the legal line from legitimate commerce into actively inducing patent infringement.
Under the Patent Act, 35 U.S.C. Section 271(b), whoever actively induces infringement of a patent shall be liable as an infringer. That word actively sits at the center of this entire fight. And Congress also created the skinny label pathway, technically called the Section 8 mechanism, so that one patent on one use of a drug doesn't block generic competition for all the other uses. The tension between those two provisions drives everything here.
Let's talk about the people behind this. Amarin Pharma markets a drug called Vascepa, which contains the active ingredient icosapent ethyl. FDA approved Vascepa in 2012 for one purpose, treating patients with severe hypertriglyceridemia, basically dangerously high blood fat levels, above 500 milligrams per deciliter, where the main risk is pancreatitis.
But then Amarin didn't stop. They ran a massive clinical trial called the Reduce It study. More than 8,000 patients across 11 countries, over 5 years, costing over $300 million, to find out whether Vascepa could also reduce cardiovascular risk. And it worked. In 2019, FDA approved a second use for Vascepa, reducing the risk of heart attack and stroke in patients with triglyceride levels above just 150 milligrams per deciliter. That's a far more common condition than the original one. Doctors called the approval a game changer and a major milestone in cardiovascular prevention. By 2020, over 90% of Vascepa's U.S. sales, somewhere between $919 million and $1.1 billion per year, came from that cardiovascular use. Vascepa and its CV indication basically became synonymous in the medical community.
Amarin patented that cardiovascular use. Then Hikma entered the picture. Hikma filed a generic drug application back in 2016, when Vascepa only carried the original severe hypertriglyceridemia indication. Hikma challenged Amarin's patents on that original indication, went to trial, and won. Courts declared all of Amarin's SH indication patents invalid.
But by then, Amarin's new cardiovascular patents had emerged. And here's where Hikma made a critical choice. Rather than challenge those CV patents, they filed what's called a Section 8 statement, basically a promise to the FDA that they would seek approval only for the unpatented SH indication, using a label that carved out the patented cardiovascular use.
FDA approved Hikma's skinny label generic in May 2020. Hikma launched in November 2020.
And here's where the trouble starts. Even before the launch, Hikma issued press releases. The March 2020 press release announced Hikma's court victory and described its anticipated product as the generic version of Amarin's Vascepa. It noted that Vascepa carries approval only in part for the severe hypertriglyceridemia indication. And it cited Vascepa's U.S. annual sales, $919 million, without breaking down how much came from each use.
A September 2020 press release did the same, citing $1.1 billion in total Vascepa sales. Neither press release mentioned cardiovascular risk. Neither mentioned statins. Both press releases directed inquiries to investor relations, not medical professionals.
Hikma's website, meanwhile, classified its generic product under the therapeutic category hypertriglyceridemia, no severe qualifier. The site also noted the drug carried an AB rating, meaning therapeutically equivalent to Vascepa, for the uses covered by the label.
And Amarin filed suit. It claimed the totality of Hikma's label, press releases, and website, taken together, plausibly alleged that Hikma actively induced doctors and pharmacists to prescribe the generic for the patented cardiovascular indication.
The district court dismissed the case. The federal circuit reversed, allowing the lawsuit to proceed. Now the Supreme Court took it.
Let's walk through what each side actually argues. Hikma first.
Hikma's main point, Section 271B, demands actively induced infringement. That word, actively, requires affirmative steps specifically designed to foster infringement. Not generic descriptions, not investor press releases, not broad therapeutic category labels. Hikma says none of its accused statements mention, encourage, or instruct the patented cardiovascular use, not once. And they lean on the Supreme Court's own decision in Metro-Goldwyn-Mayer versus Grokster, a 2005 copyright and patent inducement case, which held that liability requires evidence that goes beyond a product's characteristics or the knowledge that it may be put to infringing uses and shows statements or actions directed to promoting infringement. That's the standard.
Hikma also argues Amarin's theory of liability amounts to what they call passive inducement, the idea that physicians could read instructions Hikma never made into anodyne descriptions of the product. They call it a Rube Goldberg machine of inferences. A doctor would need to find archived pre-launch investor press releases, know the precise breakdown of Vascepa's sales by indication, interpret a bare sales figure as encouragement to prescribe off-label, and then act on that inference rather than their own medical judgment or state substitution law.
Here's the kicker on Section 8. Hikma says the Federal Circuit's decision effectively makes the skinny label pathway legally dangerous to use. Every element of Section 8 compliance, calling the product a generic version, telling investors about the market, listing a therapeutic category, becomes potential evidence of liability. Congress, FDA, and even this court use the phrase generic version to describe these drugs. Amarin used it in its own press releases about Hikma. If that phrase triggers inducement liability, nobody can safely use Section 8.
And the economic stakes Hikma raises are real. Skinny label generics saved Medicare an estimated $1.5 billion in one 5-year period. Generic drugs approved between 2018 and 2020 saved consumers over $50 billion in their first year alone. A decision that chills Section 8 filings threatens all of that. Now Amarin's side. Amarin's position. This case isn't about a label. The Federal Circuit said so explicitly. This isn't a case where the complaint rests solely on the label not being skinny enough. This case concerns what Hikma did on top of the skinny label. Amarin points to three things specifically. First, Hikma's website advertised its generic for hypertriglyceridemia, not severe hypertriglyceridemia. That broader term unambiguously encompasses the patented cardiovascular patient population, and according to Amarin, that description doesn't match Hikma's actual FDA approval because FDA approved Hikma's generic only for the SH indication, not the broader category. Second, Hikma's press releases called the product generic Vascepa without any qualification. By 2020, Vascepa and the cardiovascular indication had become essentially synonymous in the marketplace. Over 90% of prescriptions came from that use. Calling something generic Vascepa to an audience of physicians, Amarin argues, signals access to all that Vascepa does. Third, the press releases touted Vascepa's total annual sales, figures that overwhelmingly reflected the patented CV use without any breakdown. Amarin argues a sophisticated physician reading those figures would reasonably infer that the generic offered the same commercial value as Vascepa.
Amarin draws directly on Grokster's logic. The defendants in that case distributed software to known users of Napster, an infamous infringing service, and suggestively named their product to signal it offered the same functionality. The court found that combination plausibly established inducement. Amarin says Hikma did the same. It invoked Vascepa's commercial identity, which physicians associated almost entirely with the cardiovascular breakthrough, and implied its generic offered equivalent access.
On the pleading standard, Amarin pushes back hard. Hikma argues the complaint lacks particularized allegations of a causal chain, but Amarin says no law, not the Patent Act, not the federal rules, imposes that heightened standard on inducement claims. Under Twombly and Iqbal, Amarin just needs factual allegations that make the claim plausible, not proof at trial.
And Amarin points to 7 other generic manufacturers selling identical skinny label icosapent ethyl products. Amarin sued none of them. Those other companies described their products as generic icosapent ethyl, disclosed up front that their generics didn't cover Amarin's CV indication, and avoided invoking Vascepa's brand identity. Hikma alone chose a different path.
The United States filed a brief supporting Hikma, which tells you something about how seriously the government takes the Section 8 question. The government argues Amarin's complaint fails to allege a plausible causal chain between Hikma's statements and any actual prescription decision. To use the government's language, a pharmacist would need to have read an outdated investor press release, known the breakdown of Vascepa's sales by indication, construed a bare sales total as encouragement to prescribe, and then acted on that encouragement rather than following state substitution law. That sequence, the government says, doesn't constitute a plausible inference. It constitutes speculation.
The government also flags a damages concern that Hikma raised in its brief. Federal Circuit precedent could be read to require Hikma to pay lost profits calculated as if Amarin would have captured every single infringing prescription, meaning even a handful of allegedly induced prescriptions could trigger an award dwarfing Hikma's entire profit margin from the drug.
So, oral arguments. What do we watch for?
I think the justices will press both sides hard on what actively means in the statute. If Hikma wins the textualist argument, that actively requires something more than mere knowledge of infringing uses, the follow-up question becomes, where exactly does the line fall? Press releases citing sales figures? A website with a broad therapeutic category? The justices may push Hikma to identify what combination of facts would suffice to state a claim.
And I think they'll press Amarin on causation. The government's state substitution law argument cuts at a real weakness in Amarin's complaint. Most pharmacists filling prescriptions for Vascepa don't know why the doctor prescribed it. Over 92% of prescriptions for non-controlled substances never specify the indication. If generic substitution happens automatically and without regard to indication, how did Hikma's investor press releases cause any prescriber to infringe?
Watch for Justice Thomas or Justice Gorsuch to ask about the statutory text, specifically whether actively carries any independent weight or whether the Federal Circuit read it out of the statute. And watch for Justice Sotomayor or Justice Jackson to push Hikma on what conduct remains actionable. If calling your drug generic Vascepa and citing sales figures doesn't cross the line, what does?
The court may fall between justices who see this primarily as a patent law pleading question and those who see it as a structural question about preserving the Hatch-Waxman Bargain Congress struck in 1984.
Bottom line time, why does this case matter?
Because The skinny label pathway Congress created to speed cheaper generics to market only works if generic manufacturers can actually describe their products without triggering billion-dollar lawsuits. And it only works if brand name manufacturers retain meaningful patent protection against those who cross the line into actively promoting patented uses. This case defines where that line falls.
Every drug on the market today, with a patented method of use and an unpatented one, every potential generic that might come along to compete for the unpatented indication, depends on this court getting that balance right.
If you made it this far, share this episode with someone who thinks drug pricing debates happen in Congress and nowhere else, because it turns out they also happen in courtrooms and in investor press releases. You can find us on Apple Podcasts, Spotify, and YouTube. Just search the High Court Report. Follow on LinkedIn for a nearly daily rundown, and follow on YouTube to see shorts. Please follow, rate, subscribe, share, and review. It helps more than you know. Questions about this case? Reach out on LinkedIn at the High Court Report. We read every message. And look, if following the podcast feels overwhelming, just remember, it requires fewer steps than filing an ANDA with the FDA. Significantly fewer steps. Talk to you soon.